there. I know it's a post-lunch session, so I'll keep trying that you all stay awake in the entire session. Though the topic seems very simple and it's also very useful at times because that is the uh, very crucial point when you want to go for the resolution applicants, how to call them, how to invite the resolution applicant. This is the base document for that. The topic, as you all know, information memorandum. So we will be discussing it in two phases. In fact, one is what is the best practice to prepare the information memorandum, so that we don't fall prey to any kind of non-compliance or penalties. At the same time, we will also see what are the challenges associated with preparation of the preparation of this information memorandum, and how to mitigate or overcome those challenges. And I would request all of you to keep it a two-way session so that we also share our experience and whatever, so far you have done the assignments, you can also share your views accordingly. So I'm just sharing my PPT. Just let me know whether it is visible or not. I'm just making it full screen. Just let me know if it is visible.
Yes.
Okay, thank you so much, sir. Okay, so as the topic suggests, challenges in preparing an information memorandum, we all come across various kind of challenges in the whole of the assignment. This is only one of the parts. So I would just say that whatever the challenge is, we are ready to overcome that. So it is just that whether we are prepared for it or not. And mostly the things are not in our control. So we should take everything lightly, and whatever best we can do, we should be ready for that. So let us understand the basic concept of information memorandum. It is a document containing all the relevant information about the corporate data prepared under Section 29(1) of the IBC 2016. It is the foundation document to aid the resolution applicant, in short, we can call him RA, in preparing the resolution plan. So as discussed, this is the foundation or the very basic document. It is a kind of, proposal, how you can actually call the resolution applicant to come and take the, and, resolve the situation altogether. So that is why we are therefore to prepare it in such a manner that it becomes so attractive and it has all the information, so that there is no lacuna from any legal perspective. Also, from the point of resolution applicant, as soon as they have this information, they are quick enough to react. So if the complete information is not there, obviously the resolution applicant will also hesitate in the absence of complete information. So what are the key provisions or the legal provisions associated with the information memorandum? Uh, these are already reflected on your screen, like section 25 2G, wherein it is stated what is the duty of resolution professional with relation to preparation of information memorandum. Next is section 29 subsection 1, which clearly says that resolution professional shall prepare an information memorandum in the prescribed form and share with COC and resolution applicant. So it has 2-3 points if you drill it down further. First is the format. It is already prescribed and you have to prepare it accordingly. It is given in the CIRP regulations. So we will see that also. Then what is the duty of RP? Firstly, it is the duty of RP to prepare the information memorandum in the format which is specified. Then also it is the duty to share it with some limited people, and it is the COC and the resolution applicant. Next is regulation 36. It is from the CIRP regulations. It talks about the contents, format, timeline, confidentiality norms, etc. So we will also take that up later. The next is deadline. What is the timeline within which you have to prepare this? Right, as per regulation 36(1), it says that Submission of information memorandum to COC should be in the electronic form to each member of the committee within 95 days of the commencement. So T plus 95 is the final timeline which is given. So this has been amended. We all know that this particular timeline has been amended. But again, to understand, it is clearly mentioned that it is the duty of a resolution professional to submit in within a limited time frame, and it is to be submitted in electronic format to each and every member of the COC. This is clearly mentioned here. Let's move further. Let us discuss some case laws based on information memorandum so that we understand what is the actual challenge, or what is the scenario wherein if something is missing in information memorandum, though we tried our level best, but it might happen that a few things are missing, or maybe you could not finish it off in time. What will be the consequence and how these are resolved? What is the ultimate outcome? So let us understand few case laws with respect to this. The first one is ICICI Bank versus Gopal Sami Ganesh Babu. It is NCLAT decision, which we will see here. What are the facts of the case? Let us understand that CIRP had commenced and information memorandum was already circulated. So this is the background of this case, that CIRP had already commenced. We are not going into the complete details, but we will restrict our decision or our case only to the matter of this information memorandum. So we are here seeing that CIRP had already commenced and the information memorandum was already circulated. Meanwhile, a claim from a financial creditor was received after the COC had evaluated prospective resolution applicants. The RP admitted the claim and tried to modify the information memorandum and reconstitute the COC. So since there was a new claim received, the RP admitted that claim and he tried to modify the IM as well as reconstitute the COC. So what is the issue involved here? The issue is whether the RP can admit claims and alter information memorandum or COC structure after the information memorandum has been shared and the resolution process is underway. So I would request any one of you to please come up with the solution. What is there in your mind? If this is the issue, what is your take on that? Whether the RP can admit claims and alter information memorandum or COC structure after the information memorandum has already been shared and the resolution process is already in process. Any clues? What could be the judgment here?
It can be accepted till resolution plan is filed, is it not? There is a regulation.
I'm just asking, we will discuss that also. So that is why I'm just asking you to, also involve yourself and just analyze if this is the situation before you, how will you take it further? So just apply your minds and just come up with the solution. So let us go, let us understand what were the observations by the NCLAT here. NCLAT noted that such post facto changes created uncertainty. Late admission of claims after IM circulation undermines the process and disturbs the commercial decision made by COC. The final judgment in this particular case was the NCLAT held that post information memorandum alteration should be avoided unless extremely necessary and ordered that the existing process continue with original COC structure. The NCLAT set aside the proceedings where the IM was not properly prepared or shared, reiterating the RP's duty to ensure the IM is comprehensive, accurate, and timely. So if you see the final outcome, it was clearly mentioned that IM was not properly prepared or shared since few things were missing. Again, it was clearly mentioned that it is the duty of RP to ensure that IM, that is information memorandum, should be comprehensive, accurate, and it should be prepared timely. So again, the duties of RP were discussed in this particular case, as well as obviously this particular or the specific question which is raised or the issue which is raised, that was also resolved here. Let us come up to the next case law, which is SR Steel India Limited, and it is a decision of Supreme Court. Let us understand the facts of the case. Here, the concerns were raised regarding unequal sharing of information memorandum and data with the resolution applicants. So, unequal sharing would mean that few things were shared with one of the resolution applicants and few things were not shared with the other, or maybe there was unequal distribution of sharing of data. Reason we are not going into the depth why it was done, but it is just the fact that there was unequal sharing of the information memorandum and the data to the resolution applicants, though it should have been done in equal manner. So that is why the concern is raised. Some resolution applicants claimed they were not given fair access to the documents, affecting the bidding process. As we all know, it is the duty of the resolution professional to allow access to the resolution applicants to check the documents, to check the records and all. But here, the resolution applicants are claiming that they were not given fair access to the documents, affecting the bidding process. What is the issue involved? I think we all have analyzed it right now. That the issue involved here is whether non-uniform sharing of information memorandum or data violates the fair process under the IBC. So is it a kind of a violation, or how is it? How should that be taken here? So what are the observations here from the Supreme Court? The Supreme Court emphasized that all the resolution applicants must be given equal access to information and opportunity to bid. What was the final judgment? The court upheld the principle of level playing field and reinforced RP's duty to share information memorandum uniformly. So again, in this case also, we are seeing that the duty of resolution professional with respect to the preparing and sharing of information memorandum is discussed here. The Supreme Court upheld the primacy of the COC, but mandated that resolution plans must not discriminate between similarly situated creditors, and that the process, including the IM preparation, must be robust, transparent, and compliant with the law. So that is something which we all understand, and that is the importance of IM. So if equal chance is given to all the resolution applicants, only then proper or fair bidding can be conducted. Let's move further to the next case law. It is Binani Cement Limited. Let's discuss the facts of the case. Here, the resolution applicant alleged that it was not provided adequate data from the information memorandum and data room, while other applicants were favored. So it's a similar kind of case. Here, the issue involved is whether the RP can discriminate between the applicants in IM sharing and data access. So there's one more case with regarding the sharing of the data. The observations of NCLT and the observation of tribunal here, in fact, the tribunal stated that the insolvency process must be transparent and non-discriminatory, and the final judgment is it set aside the discriminatory practices and reiterated that IM must be shared equally and fairly with all the qualified resolution applicants. The Supreme Court upheld this approach. So this case further went to Supreme Court, and there also this approach was upheld, reinforcing the need of fairness and transparency in the CIRP. Next case is Reliance Infratel Limited. It is the Delhi NCLT judgment. These are the facts of the case. Certain significant contingent liabilities were not disclosed in information memorandum. So I think we all understand when to disclose contingent liability, and in fact, what should be described or what should be disclosed in if you are at all disclosing the contingent liabilities. So if it is materially impacting, you have to give the quantum also, the amount also in case of contingent liabilities. But here it is mentioned that certain significant contingent liabilities were not disclosed in the information memorandum. COC members later raised objections claiming incomplete information. What is the issue involved? Can omission of contingent liabilities from information memorandum be considered suppression of material facts? So anyone would like to express your views on this matter? Can omission of contingent liabilities from information memorandum be considered suppression of material facts? Can it be said so? I think I've got
yes.
something in the chat box. Yes, two people have said. Sham Dhanuka ji sir has said that yes, it amounts to omission. Okay, let's see what are the observations. Tribunal found that RPs must err on the side of full disclosure, even if liabilities are disputed or uncertain. So far as you have the information, it is your duty to disclose it. Final judgment, RP was directed to update and recirculate the IM with all relevant information. So in this case, RP was not penalized, but he was just asked to, just update the information memorandum, taking in or considering all the relevant contingent liabilities, and then recirculate the information memorandum with all the relevant information. Ensuring all relevant information was included and shared with the COC and resolution applicants, reinforcing the RP's central role in ensuring transparency and compliance. So again, we have to understand what is the duty of insolvency professional, or what is the duty at the time of preparation of this information memorandum, because at every point of time you have different duties. So while preparing the information memorandum, complete disclosure is must. Equal sharing of data, again, that is very important. And here again, if you have the information, you should not make a discretion whether you should disclose it or not. But if you have the information, you should go for it and you should disclose it on a safer side. So that is meant by transparency and proper compliance. Let's go further. There's one more, I think 2-3 cases are more. Jayanta Banerjee versus Shashi Agarwal, liquidator of InCab Industries Limited. This is a decision of NCLAT. Following are the facts of the case. Entire CIRP was conducted without preparation of an information memorandum or valuation of the corporate debtor. So this is a unique case wherein whole CIRP was conducted without preparing the information memorandum or valuation of the corporate debtor. The COC was constituted based on unverified claim, and the decision to liquidate was taken without proper process, including the absence of Form G, publication for inviting expressions of interest. So what is the issue involved? I think this is very much clear to all of you whether this kind of situation or this kind of thing can happen or not. So whether the failure to prepare an IM and follow due process invalidates the constitution of the COC and subsequent liquidation order. What's the answer? Yes, I have got the answer from one of the participants.
Yes, it will invalidate the process.
Yes, sir. So it's very much clear nowadays. I mean, maybe in the earlier times there was a confusion or something, but nowadays it is very much clear. The NCLAT found that the information memorandum is a critical document for CIRP, enabling proper valuation and inviting resolution applicants. The absence of an information memorandum and failure to verify the claims before constituting the COC tainted the entire process. It emphasized that all CIRP regulations are interlinked and must be strictly followed. So again, obviously, if you are not preparing information memorandum, then you are not following the CIRP regulation, because it is specifically mentioned therein that you have to prepare information memorandum. What is the final judgment? The NCLAT set aside the liquidation order, holding that the constitution of the COC and subsequent decisions were invalid due to non-preparation of the information memorandum and non-compliance with the CIRP regulations. So if I talk about from the perspective of the resolution professional who was in that particular case, the case which we have just discussed, wherein he did not even prepare the information memorandum. So whether it will amount to misconduct, non-preparation of information memorandum, whether it amounts to misconduct, whether disciplinary committee can take action against a resolution professional in this particular case.
Yes, they can.
Okay. Thanks for your answer, sir. Let's see and let us discuss here the facts of the case. An RP could not prepare the information memorandum because the corporate debtors' premises were sealed by the Chennai Metropolitan Development Authority. The reason could be any. Here, the reason they have specified that the premises were closed, and since no information could be gathered, he could not prepare the information memorandum. The disciplinary committee initiated action against RP for non-compliance. So what is the issue involved? Whether an RP can be penalized for failing to prepare an information memorandum due to third-party actions. Here the third party is this Chennai Metropolitan Development Authority. They did not allow him to enter the premises. It was completely sealed. So can RP be penalized for someone else's action?
No, I don't think so. Then, in this case, yeah, it's a bit. Although RP could have filed with AA Adjudicating Authority for unlocking of the premises.
Right, sir.
I don't know what action RP has taken in this case.
Yes, so let us see that. Sir is very much correct. Observations, we are discussing the observations now. The DC acknowledged the RP's efforts to access records, including obtaining court orders, but CMDA non-cooperation prevented the whole compliance. The NCLT and NCLAT had already exonerated the RP in earlier proceedings. Hence, the final judgment is the DC dropped the charges, recognizing that external factors, not the RP's negligence. This word is very, very important. If RP is negligent, if he is found negligent, that means he himself ignored the things, or purposely he did not, prepared the information memorandum or something. If he is guilty in that sense, then obviously DC can take action. But if it is done due to, he was not being allowed or he was restricted by some third party, this will not be his misconduct. So
The liquidation must have been ordered by AA only.
yeah, that is why it is mentioned, sir, in the earlier proceedings. In fact, RP was not held to be guilty in that.
How the liquidation was ordered?
So we are not discussing that liquidation case and all. I am just discussing this particular case. Otherwise, sir, that will take longer time. Because in every case, there are many aspects to be discussed. We are just focusing on a single aspect, that is the information memorandum. And if you fail to prepare the information memorandum, how you can take up the case further. Next. Vijay Kumar Jain versus Standard Chartered Bank and others. Facts of the case. The appellant, a member of the suspended board of directors, sought directions for the RP to provide all relevant documents, including the resolution plans and information memorandum, during the CIRP of the corporate debtor. What is the issue involved here? Whether the members of the suspended board of directors are entitled to receive the information memorandum and resolution plans during CIRP. Now, I want you people to answer for this.
No, he can't.
Yes, ma'am. The suspended management is eligible for information memorandum and ration plans.
Are you sure, sir?
Madam,
Yes,
they
ma'am.
are entitled to receive the IM and resolution plans.
We means who, sir? We are asking about the suspended board of directors.
Suspended board of directors are entitled.
They are
They are
entitled to
not,
receive.
they
Yes,
are
ma'am.
not entitled, ma'am. The suspended board of directors cannot
In fact,
ask for
madam,
IM.
in one of my case, the suspended board of directors approached IBBI. They even filed an IA that I am not sharing the IM and resolution plans.
So this case will be, eye opener for you, sir. Again, you can take cue from here also. See, the Supreme Court observed that under Section 24, subsection 3 of IBC, participants, that is including suspended directors, are entitled to notice of the COC meetings and to receive copies of the documents relevant to the matters to be discussed. However, the right to receive the information memorandum is not absolute and is subject to confidentiality requirements. We all know that non-disclosure agreement is signed and then only information memorandum is shared. The court clarified that while directors have a right to participate and access the certain documents, this does not automatically extend to all the confidential documents like IM unless specifically relevant to the agenda. So what is the final judgment in this particular case? The Supreme Court partly allowed the appeal, holding that suspended directors have a right to receive the documents placed before the COC for the decision making, but not a blanket right to the information memorandum. The RP must balance transparency with confidentiality. So ultimately, the result is it's not that directly they have the authority to receive. They don't have this kind of right, suspended board of directors. But if something is related to the discussion and if that kind of document is required, they may demand for that. Directly, they do not have any right to receive such information memorandum. There's one more case. I think this will make the things more clear. Vinay Kumar Singhal, RP for PG Advertising Private Limited versus Mahesh Bajaj. This is NCLAT decision. This is also related to the same context which we are seeing. The suspended board of directors sought access to the information memorandum. The RP refused, stating that information memorandum is confidential and only for the COC members and resolution applicants. So what is the issue involved? Whether the RP is obligated to share the information memorandum with the suspended board of directors or only with the COC members and the RA, because the regulation clearly says that RP has to share it with COC members and RAs. So that is the question involved here. So observation by the NCLAT, the NCLT Mumbai bench and the NCLAT distinguished between members and participants as defined in the CIRP regulations. It noted that the code and regulations only provide for sharing the information memorandum with COC members and resolution applicants after confidentiality undertakings, not with participants such as the suspended board of directors. The Supreme Court's decision in Vijay Kumar Jain, which we just discussed previously, was held to apply only to COC members and not to the participants. What is the final judgment here? The tribunal held there was no violation of the code or regulations in not furnishing the information memorandum to the suspended board of directors. So I think the case is clear, sir. There's one more point here. The information memorandum is to be shared only with COC members and resolution applicants, maintaining its confidentiality. So again and again, we are seeing that this document is to be shared with whom, and before sharing, you have to obtain this confidentiality agreement. That is very, very important. So we will take a break here. I am not asking you to go anywhere. It is just that we will have a short quiz based on whatever we have studied, and I'll not say whatever we have studied, but it will be based on the your information or your knowledge about the subject. So I'm just stopping the screen share here. I'll move on to the quiz. I hope you all are ready to take the quiz. Let me hear yes.
Yes.
It's my duty to keep you awake now, so that is why this short quiz is prepared. Just give me a minute to start that. So you can unmute and answer, or you can provide that in the chat box as you like. So just a second, I will be sharing the screen. Let me know if it is visible.
No,
Yes.
It's visible, right, sir? Okay, so here comes question number 1. Ready?
yes, I'm ready.
Okay. Okay. So the first question is, under IBBI CIRP regulations, the information memorandum is required to be prepared under which regulation? You need the options, or you can say it directly. Has anyone given the answer in the chat box? Not yet. You remember the regulation number, or should I give you the options? Let me know. C1 29A. No, sir. I'm asking the regulation number.
Is it 25?
No, that is not the correct answer. I'm just reading the answers in the chat box.
Regulation 25.
Sir, we are talking about regulations. There is some confusion between sections and regulations. Whatever you are saying are the sections of the code. 25, 29, what is the difference in those? We will study that also. So at least we must understand, because this is a very basic thing, under which CIRP regulation it is mentioned to prepare the information memorandum. Okay, let me give you the options. It's regulation 34B, regulation 36(1), regulation 36(2), or regulation 36 or regulation 37. So 36(1). I hope you have not Googled it. Okay. So the answer is B, obviously. It's
36(1).
regulation 36(1) to be very specific. It talks about the requirement of preparing the information memorandum. And let's see who has given the correct answer. So Sukhdev ji has given the correct answer. So whose name starts with YS? Because since it's such a short form, so I do not know the full name. YS. And Sujit ji has also given the answer. Babita ji, Sukhdev ji, they have all given the correct answers. Okay, let's move on to the next question. I hope you will all remember regulation 36(1) is for the preparation of this information memorandum. Okay, so next question. As per regulation 36(2), which of the following is not a mandatory disclosure in the information memorandum? So it indirectly tells you that what you have to disclose is mentioned in 36(2). So again, 36(1) talks about the preparation of memorandum. Then contents, what should be the content? It is given in 36(2). And here the question is, what is not mandatory disclosure? That is something which you have to point out. So option A is list of shareholder, list of creditors, list of assets and liabilities, or details of guarantee given. What is the correct answer?
A
List of creditors.
List of shareholders or list of creditors? Mostly people have given A as the correct answer, and that is correct. In fact, a list of shareholder is not explicitly required under regulation 36(2). Next question. Which section of the IBC empowers the resolution professional to access books of accounts and other documents? Section 17, 20, 18, or 25. Now we are talking about sections. So which section of IBC empowers resolution professional to access the books of accounts and other documents? because that is required for preparation of IM. DP Gupta sir has mentioned A. Okay, any other answer? Section 18, Gaurav Mittalji is saying section 18. Okay, so should I give you the correct answer? Correct answer is C. Gauravji is correct. Then section 18C allows access to books and records. Screen sharing has been paused. Just a second. Is my screen visible?
Yes, ma'am. Yes, ma'am.
Okay. We were on this question. Now, question 4. Information memorandum must be shared with resolution applicants only after filing of COC formation report. B. Non-disclosure agreement is signed. C. Approval of Form G. Or D. Filing of audited accounts. I think this is a simple one. Let's see who gives the correct answer. Oh, quickly, I have received B from Neeraj ji, Gaurav ji, Shyam sir, and who all? Yeah, many people have given the correct answer. Correct. Obviously, it is B. Moving on to the next question. Which of the following is not part of other material information under regulation 36(2)H? So we will discuss this 36(2) regulation, wherein we have just discussed in the previous question that it contains the, it describes the contents, what all you have to disclose in the information memorandum. So there are various clauses or sub clauses there. So in the H sub clause, which point is not a part of other material information? So H clearly talks about other material information. So which of these is not a material information which is to be disclosed, or which should actually it should not be disclosed in IM? Has anybody answered? Okay, Manoj ji is saying B, Neeraj ji is saying D, Sunil sir is saying B. Okay. Okay, let's see. The correct answer is B. Resignation of CS 2 years ago is not material unless it relates to fraud or concealment. That is correct. Next question. If the resolution professional fails to prepare the information memorandum, it may be considered a violation under which of the following sections? So now we are discussing if resolution professional has failed to prepare the information memorandum. So it is considered as a violation, but under which particular section will it be categorized? So Babita ji is saying A, Gaurav ji is saying A, DP Gupta sir is saying A, Neeraj ji is also saying A. The answer is A. Section 208 Clause A requires an IP to exercise the due diligence. So again, it is a part of due diligence only that you have to prepare the IM in the way it is prescribed. Next, RP must provide IM to COC members at their discretion or only if it is requested. Option C, as soon as it is ready or at least 2 days before the COC meeting. I think this is also simple one. C, I am getting C as the answer. Okay, that is correct. Answer is C, that is as soon as it is ready, you have to deliver it to the COC members. The next is regulation 36A allows resolution applicants to access information memorandum if they are part of the COC or they sign a non-solicitation agreement. The spelling is incorrect here. They submit EOI and pass eligibility, or they submit Form D. What is the correct answer? B, mostly I'm getting B answer. Let's see. The answer is C. They submit EOI and pass the eligibility. Then only the resolution applicants will have the access to information memorandum. You all understand that expression of interest they have to submit, and then obviously there is an eligibility criteria which is given in 29A that they have to clear firstly have this information memorandum. We'll take 2-3 questions more and then we will go back to our normal presentation. Which form is filed by RAs to access IM? Which form is filed by resolution applicants to access the information memorandum? Is there any form for that?
I think answer will be C. I think.
C is confidentiality undertaking. That is perfect, right? This was a simple, and just to sometimes these form numbers, they twist our understanding at times that there might be some form. Who is responsible for the accuracy of the information memorandum? I think this is very much clear. It's C. I'm not taking it further. Question number 11. Section 70 of the IBC provides for penalties in case of. So what are the situations for penalties which are mentioned in section 70? C. Mostly people are saying C. The correct answer is C. Congratulations. Misconduct during CIRP by CDs or officers, that is mentioned there. Just we'll take 1 or 2 questions more. That is it. Under IBBI's disciplinary regulations, delay or inadequacy in information memorandum may attract what amongst these? Removal from COC, B, penalty up to ₹1 crore, C, suspension of IP registration, or D, withdrawal of CIRP. So if someone files case against you and this disciplinary regulations are attracted, then in that case, what will happen? What is the answer? Let's see. C is the correct answer. That is suspension of IP registration. Last question. If the RP does not disclose material information and the plan fails post-approval, the liability may arise under which section? If the RP does not disclose material information and the plan fails post-approval, the liability may arise under which of the following sections? Section 54, 208, 35 or 21?
Desktop ಇತ್ತು
208 people mostly are saying B because code of conduct is already mentioned there. So it's easy to guess. Yes, it's correct because again, it is your duty to disclose, and if you have not disclosed material information, in that case, you have violated the code of conduct also. So it is very much clear. I think we can go back to the main topic now. I think you all are good to go. Okay, we are starting the normal presentation, which was about the challenges which we were talking earlier. Okay. Let me know if the screen is visible. What time we need a break? Tea break at 4? Just let me know if the screen is visible.
Anji, madam, Anji.
It's a CS Institute publication. Can you see that? It's a CS Institute publication. Can you see that?
No, ma'am, it's CS material.
Yes,
Just
yes.
written.
It's the same thing, sir. It's the same thing.
Yeah,
So-
ma'am, it's visible.
Yeah. Okay. So here it is specifically designed for the purpose of preparing the information memorandum. It has everything related to information memorandum. what is the meaning, what are the provisions, everything. It is contained here. So I'm directly taking you to the main topic, which is these sections. Basically, we need to understand the provisions where it is mentioned that we are supposed to prepare information memorandum and how it has to be done. So section 510, basically it contains the definitions. So information memorandum is defined in section 5 clause 10. It means a memorandum prepared by resolution professional under subsection 1 of section 29. So it is redirecting us to section 29. So whatever you are preparing under section 29 will be considered as information memorandum. That is what it is mentioned here. Then section 25 2G basically talks about the duties of resolution professional. So here in 25 subsection 2 clause G, it clearly says that it is the duty of the resolution professional to prepare the information memorandum. Again, it is saying that it has to be done in accordance with section 29. So again and again, section 29 has been made very, very important. So let us come to this section 29 and understand the provisions here.
मैम
Section 20, yes.
मैम ये आपकी स्लाइड मूव नहीं हो रही है मैम, वो फर्स्ट स्लाइड पे ही है मैम.
अच्छा, मैं 1 मिनट फिर बंद करके वापस चलाती हूँ फिर 1 मिनट. अच्छा, वो आपने बता दिया. 1 मिनट. अभी दिख रहा है? Is it visible now?
Yes, it is visible.
We were here.
Yes.
We were here. Section 510. Could you see this earlier, or should I take this again? Section 510. It talks about the definition. What is the definition of information memorandum? Then here also it is mentioned that refer to section 29. Then we are talking about the duties of resolution professional, which is contained in section 25. It again says that it is the duty of resolution professional to prepare the information memorandum according to section 29, in accordance with section 29. So now it is very important for us to understand what is there in section 29. So here we are. Section 29 of the code, it talks about preparation of information memorandum. So it has 2 subsections, that is it. So first subsection says that the resolution professional shall prepare an information memorandum in such form and manner containing such relevant information as may be specified by the board for formulating a resolution plan. So it is clearly mentioned that board will give the guidelines, or it will give the regulations how the format of this information memorandum will be, what will be contained in that. So we all understand that CIRP regulation, they have already framed it and it has prescribed the details also. And there's a specific format also, we will discuss that, which is guided by the board. Then next, subsection 2, it says that the resolution professional shall provide to a resolution applicant access to all the relevant information in physical and electronic form. Just understand the difference. In the first subsection, it was mentioned that resolution professional is supposed to prepare the information memorandum. The format and everything will be given by the board. That is the first thing which he has to do. The second thing now is, once you have prepared the information memorandum, obviously that is to be shared with someone. So it will be shared with COC and resolution applicant, but this is nowhere mentioned here. It is mentioned in the regulations. Here, there is a separate thing which is given. It is mentioned that it is the duty of the resolution professional to provide access to the relevant information in physical and electronic form, provided such resolution applicant undertakes. So resolution, who has to be provided with all these information? Resolution applicant should be provided access to the information. Why it is our duty to provide him the access? Because ultimately the whole control is with the resolution professional. So he has to allow some persons for the access. So who is coming into that certain category of persons? So this resolution applicant, because he will be actually analyzing whatever is mentioned in information memorandum, or he will be, keen to understand the position of the corporate debtor. So therefore, some informations are to be provided to him, and if required, they are allowed to access those information also. So 3 points are mentioned, A, B, and C. A, to comply with the provisions of the law for the time being in force related to the confidentiality and insider trading. So before allowing the access, 3 points are to be taken care by the resolution professional. So he has to ensure that all the 3 points are taken care. First is, he has given a confidentiality agreement, which is simply mentioned here, to comply with the provisions of law of confidentiality and insider trading, that this information this will not be used for insider trading purpose. Second, to protect any intellectual property of the corporate debtor it may have access to. So again, this is mentioned in the non-disclosure agreement itself, that the resolution applicant will not use it for the intellectual property purposes and all. So it is the duty of the resolution professional to protect the intellectual property of the corporate debtor, because he is allowing the access to outsiders. Then third is, he is not supposed to share the relevant information with the third parties unless clause A and B of this subsections are complied with. So again and again it is mentioned that any information sharing which is to be done with the resolution applicant is or can be done only after fulfillment of A and B points. So all these points are very, very relevant. So it again defines what is the duty of the resolution applicant. Okay. Now here, relevant information is also defined or explained. For the purpose of this section, relevant information means the information required by the resolution applicant to make the resolution plan for the corporate debtor, which shall include the financial position of the corporate debtor, all information related to the disputes by or against the corporate debtor, and any other information pertaining to the corporate debtor as may be specified. So again, what kind of information you can share with that resolution applicant, this is also specified. Next is section 30. Section 30 of the code talks about the submission of the resolution plan. So here again, reference is given to the information memorandum, because resolution plan will be based on the information memorandum data, whatever data is there or whatever the information is there in this IM. On the basis of that only, resolution plan will be designed. So a resolution applicant may submit a resolution plan along with an affidavit stating that he is eligible under section 29A to the resolution professional, prepared on the basis of information memorandum. So this is contained here in section 30 of the code. Next is section 33, which is related to the liquidation. So for the initiation of liquidation, something is mentioned with respect to information memorandum also. So that particular part only we are concerned with. So in the explanation of this particular section, it is given that for the purpose of this particular subsection, it is hereby declared that the committee of creditors may take the decision to liquidate the corporate debtor at any time after its constitution under subsection 1 of section 21 and before the confirmation of the resolution plan, including at any time before the preparation of the information memorandum. So even if information memorandum is not prepared, before that also, I mean, simply the liquidation can be initiated. So this is mentioned here. So someone was asking earlier also how liquidation could happen if information memorandum is not prepared. So this point is given here in the explanation also. Next, moving further, section 240 of the code. We are still on the code only. Regulation we will discuss later. So section 240 of the code clearly talks about the power to make regulations. So obviously board has the authority to formulate the regulations. So here exactly, if we want to know where it is mentioned that information memorandum format and all will be prepared or guided by the board, it is mentioned here in subsection 2 clause U, the form and manner in which an information memorandum shall be prepared by the resolution professional. It will be done or it will be given in the regulations by the board. So it is clearly mentioned here. Now, next coming to the regulation 36. So for regulation 36, I will be taking up directly from the CIRP regulation, not from here, so that we understand it a very proper manner. So I'll just stop my screen sharing here. I'll open the CIRP regulations and then again I will share the screen. We are understanding the flow of or the contents which are there in the code itself for the information memorandum. So what all sections are there which guide us to prepare information memorandum, and what are the related rules and regulations? That is something which we are understanding in today's session. Okay, so this is the CIRP regulation. I'm directly going to regulation 36. I hope you all remember. Regulation 36 is talking about the preparation and everything of information memorandum. So it is the, I think this is visible now. Regulation 36. Is it visible? Is my screen visible?
Yes.
Okay, so thank you so much. So regulation 36 talks about how you have to prepare and what are the contents of the information memorandum. So there are broadly 4 clauses here, 1, 2, 3, and 4. So we will talk about them one by one. Normally, the first sub-regulation, it says that subject to sub-regulation 4, the resolution professional shall submit the information memorandum in electronic form to each member of the committee on or before the 95th day from the insolvency commencement date. So here it is clearly mentioned that to the committee to the COC members only. I mean, for the COC members, it is mentioned here in regulations. For the resolution applicant, it was already mentioned in the code itself in section 29 where we studied about it. So information memorandum, obviously it has to be prepared by resolution professional. Format will be electronic format, and then it has to be shared with the COC, and the timeline is also mentioned here, on or before 95th day of the insolvency commencement date. So this is about this sub-regulation 1. Then coming to sub-regulation 2, it is giving you the contents, what should be there in the information memorandum, the headings which all should be there. So the information memorandum shall highlight the key selling propositions and contain all relevant information which serves as comprehensive document conveying significant information about the corporate debtor, including its operations, financial statements, to the prospective resolution applicant, and shall contain the following details of the corporate debtor. So it has specified what all details you require. So here we can see from clause A till H. In fact, I is also there. So after till A to I, we have to study it one by one so that we understand, we don't miss out anything while preparing the information memorandum. So first is talking about the assets and liabilities. Here it is clearly mentioned, including contingent liabilities. And here you can see that this has been amended after the decision. So assets and liabilities, including contingent liabilities, with such description as on the insolvency commencement date, as are generally necessary for ascertaining their values. Here the explanation is given. Description includes the details such as the date of acquisition, cost of acquisition, remaining useful life, identification number, depreciation charged, book value, geographical coordinates of the fixed assets, and any other relevant details. So what is the easy approach? You can actually prepare a columnar chart for each and every asset and liability, and you can prepare the complete data, whatever is required. So this is about the assets and liabilities. Second is the latest annual financial statements. It is saying about the latest annual financial statements. Third is audited financial statements of the corporate debtor for the last 2 financial years and provisional financial statements for the current financial year made up to the date not earlier than 14 days from the date of the application. So again, this is very, very important, till which date provisional financial statements are to be prepared. Sometimes we do not put that information in the information memorandum. So here it is actually mandatory that this much information is to be given in the information memorandum. Next is a list of creditors containing the names of creditors, amounts claimed by them, the amount of their claims admitted, and the security interest, if any, in respect to such claims. I request all of you to please mute so that everyone can hear properly. Kindly everyone mute yourselves. Okay, next is E clause. It says that particulars of a debt due from or to the corporate debtor with respect to the related parties. So related party information is also to be disclosed if any debt is due to them or if any debt is due from them, both the cases. F clause, it says that details of guarantees that have been given in relation to the debts of the corporate debtor by other persons, specifying which of the guarantors is a related party. So two kinds of information for the related parties, debt due as well as the guarantees. So guarantees will have again two limbs. One is if it is related to any related party or other parties. So that way you have to disclose. Then G, it says that the names and addresses of the members or partners holding at least 1% stake in the corporate debtor along with the size of the stake. So normally list of shareholder is not required. However, name and address of the members or partners holding at least 1% stake in the corporate debtor along with the size of the stake, that is mandatory here. Next, H is details of all material litigations and an ongoing investigation or proceeding initiated by the government and statutory authorities. Nowadays, this is also very important, and actually it is very crucial to mention what all litigations or pending matters are there. So a detailed report is to be given in the information memorandum with respect to this. Then next is, maybe you can prepare a separate annexure for this particular thing. Next is the number of workers and employees and liabilities of the corporate debtor towards them. So specifically they have highlighted if there is any liability towards workers or employees, that is again to be separately disclosed. Then we have J till L, we have total. So we are coming to this J point. Company overview, including snapshot of business performance, key contracts, key investment highlights, and other factors which bring out the value as a going concern. I think we all understand this and we are all preparing this. So I don't think there is much problem here. Next K, details of business evolution. So background or the history of the business. Industry overview, key growth drivers. These 2 points are related to companies. So they are discussing about the past performance and the future, which anyone, the resolution professional is saying that this could be the future of the firm. So this entity will have a good future based on the market analysis and all. So that way you are portraying the good picture of the corporate debtor. So this is based on that. Here it is saying that details of business evolution, industry overview, and key growth drivers in case of corporate debtor having book value of total assets exceeding 100 crores rupees as per the last available financial statements. So this is mandatory in the case case with this criteria. Next, this is an addition. This has been amended here. Fair value. Even the fair value of the assets has to be mentioned in the information memorandum. However, there is a proviso given, provided that the committee may decide not to disclose the fair value if for reasons to be recorded in writing, it considers that such non-disclosure to be beneficial for the resolution process. So if the committee thinks that it is good not to show fair value, otherwise resolution applicant might not come and take up the, or it might show the undervaluation or something like that. So in that case, why to show the proper valuation of the company or it is purely the decision of the COC. So if you don't want to show the fair value, then again, it is the duty of RP to obtain this in writing. It is clearly mentioned you have to record it in writing from the COC that non-disclosure is beneficial for the resolution process. So obviously this has to be taken care by the resolution professionals. And lastly, it talks about the other information which the resolution professional deems relevant to the committee. So whatever other information, if you think that is necessary to be disclosed, then this point is there. Then we have third sub-regulation. It says that regulation 3, a member of the committee may request the resolution professional for further information of the nature described in this regulation, and the resolution professional shall provide such information to all the members within reasonable time if such information has a bearing on the resolution plan. So further information can be demanded. This is mentioned here. Then again, there is an amendment 3A. The creditor shall provide to the resolution professional the latest financial statements and other relevant financial information of the corporate debtor available with them. This is a very, very important point. And we all understand that while preparing the information memorandum, sometimes there is non-cooperation by the corporate debtor. We don't have proper access to documents or records. Maybe the financial statements are, not prepared. So whatever information is there with the third party, that is the creditors also, you can approach them and collect the latest financial statements, whatever is there with them. So I'm reading this again. The creditors shall provide. So it is the duty of the creditors to provide you. The creditors shall provide to the resolution professional the latest financial statements and other relevant financial information of the corporate debtor. It might include the stock statements, GST returns, or whatever, or IT returns, whatever is there with the creditors, they can provide you, and this will help in preparing the financial statements. Next, fourth sub-regulation. The resolution professional shall share the information memorandum after receiving an undertaking from a member of committee to the effect that such member or resolution applicant shall maintain confidentiality of the information and not to use to obtain any undue gain. So normally, since, as we saw in the case of resolution applicant also, non-disclosure agreement is to be signed and then only he will be allowed access to the information. Similarly, if COC is given this information memorandum, from them also a confidentiality agreement is signed. So this is what is contained in this regulation 36. I'm just stopping the screen share. We will now back to can you all please mute yourself? Whosoever is there with the name Dell. Host, can we please mute them from our side?
9 lakhs addition in the 5 lakhs even that asset value. Okay. 5 lakh ಇದೆ ನಮ್ಮ ಹತ್ರ ಅಷ್ಟೇ value.
Since I'm close, maybe I can. Yeah. Okay. So,
Ma'am, I have one question.
Sure, sir. Yeah.
Ma'am, regarding clause A, which it says the date of acquisition and depreciation asset wise, that is normally not available because mostly companies do not prepare fixed asset register as required under Companies Act.
Right, sir, right.
And then second clause B, that 14 days prior, then mostly that information is not available. So how to cope with that?
So again, we have to disclose it in the information memorandum. We have to clearly specify. We will come in about this particular concern of yours in the PPT itself. It is mentioned there. Yes, sir. So you have to make it in writing that whatever information you had, you have prepared the data accordingly. And whatever you did not have, you have to specify that these were the information which were not available, and hence the whole thing could not be. Position is not very much clear. So that way, how you have to draft it, I have given that also in the PPT. So I'm just going back to the presentation. Okay, is it visible? Okay, so we
Yes,
are here
yes.
now. What are the common non-compliance in information memorandum, which disciplinary committee or maybe IBBI has reported? So these are some of the common non-compliances which are observed in information memorandum, and what will be their impact or what is the risk associated with that. So first is the omission of litigation or contingent liabilities. So if uh, litigation matters or the contingent liabilities are omitted to be recorded in information memorandum, then obviously we can understand that the resolution plan may be challenged post approval also. So it will have that kind of risk. So this will amount to non-compliance, obviously, because this is specifically mentioned in the regulation that you have to mention the contingent liabilities as well as the litigation matters. The complete detail has to be there. Next is inclusion of outdated or inflated asset values. Sometimes it happens that uh, we are not paying so much concern to the values, asset value. So whatever, just to attract the a resolution applicant, maybe the inflated asset values are taken, or the even if the asset is outdated, we are taking that into the account. So what will happen or what will be the impact of that? It will obviously give misleading information, or it will mislead COC and RAs, and invites disciplinary action as well. So we have to be very cautious about this particular thing. So outdated things or the stock, sometimes it has expired and you are still taking it into account. So that should not be done. Then missing material disclosures like expired license, NOCs, if they are not renewed, if you are not, mentioning that clearly in the information memorandum, that again is a kind of non-compliance. Here, RAs may back out or revise the bids. That could be the impact. Next is delayed information memorandum preparation. So if you are not following the timeline, that is also a kind of non-compliance. And here, breach of statutory timeline may delay the CIRP, which we all can understand. And obviously, it may, if you are proved to be guilty or if you are proved to be negligent, then obviously disciplinary action can be taken on the insolvency professional also. Next is improper sharing of information memorandum. For example, before NDA, that is non-disclosure agreement. So it is again and again mentioned in the code and the regulation that you have to take confidentiality agreement before handing over this information memorandum or any other document or detail to anyone. So again, if you are not doing that, that will amount to non-compliance. It will be breach of confidentiality and legal liability of the insolvency professional. So these are some common non-compliances which have been observed. So what is the role and responsibility of the insolvency professional? So we all understand that a lot of duties and responsibilities are imposed on the insolvency professional, even though the environment is not very friendly to us. We still have to abide by the law and we have to do everything within the time frame also. So let us firstly understand what is the role and responsibility and how we can mitigate all these challenges that also we will see in the further slides. So first role or the first responsibility of the insolvency professional is to collect the data. If you have the complete data with you, then only you will be able to prepare a good information memorandum or a comprehensive information memorandum. So data collection is very, very important. So what all data you should collect? You should collate all the financial, legal, operational data from the CD's books, statutory filings, management, auditors, and forensic reports. The next duty is to validate and check the accuracy of what all data you have. So first thing is you collect the data and then you analyze whether it is accurate, or you have to now validate that particular data. So cross-check the information for completeness and correctness. This includes reconciliation of claims with books, verification of litigations from legal databases, and due diligence with the statutory authorities. Next is confidentiality compliance. Ensure that IM is shared only with those who submit the confidentiality undertaking. This, I think we all understand now. And here it is also mentioned that the RP must maintain logs of who access the information memorandum and ensure no leakage. I wonder how many of you prepared log for that. So if you are not doing that, please, it is advised in order to, protect yourself, just have or maintain this kind of log also who has accessed the documents or the information memorandum, etc. Next is engagement with stakeholders. Liaising or lies with the COC for inputs on evaluation metrics, market feedback, and required disclosures. The RP may also interact with the prospective resolution applicant to clarify data without breaching any kind of confidentiality. So it is always said that communication is the key. So the number of times or the kind of communication you have, that will make us bond very strong, and that will actually resolve the situation very fast. So communication with all the stakeholders at times improve the overall strategy. The next responsibility is valuer coordination. For the valuation purpose, obviously, assist in the, so it's our duty to assist the valuer, assist in the appointment of two registered valuer to determine the fair and liquidation value, share the required information memorandum data with the valuers as per regulation 35(2). So once, because we have to provide the data to them and then they will analyze. So it's our duty, obviously, to provide them the correct data. Maintain a data room. That is also our responsibility. Host a virtual or physical data room with access logs and facilitate document sharing for RAs to conduct the due diligence. Next is uphold the integrity. The RP must not influence the COC or RAs by omitting material facts. Their independence and objectivity in the IM process is central to a credible CIRP. Next is disclosure and reporting. Obviously, it's our duty to disclose and report out the facts. The RP must report the status of IM preparation and sharing to the adjudicating authority and IBBI, especially in cases where delay is unavoidable. So again, if you think there will be delay in preparation or anything, then it is your duty to communicate it with the adjudicating authority or any of the stakeholders. Next, what is is there any kind of consequence of non-compliance? Is there any penalty provision, or what could be the action? So that is what we will see in this particular slide. What are the consequences of non-compliance? So first is very simple. If you fail to prepare the information memorandum according to the provisions of the code or the regulations, then in that case, it will amount to breach of section 25(2)(g), where it is stated that it is your duty to prepare information memorandum according to the rules and regulations or the code itself. And obviously 29(1), which again imposes a kind of responsibility on the information on the insolvency professional, that you have to prepare information memorandum with all the contents, with the particular format and everything. So if you are not preparing it in that way, it will be considered as a breach on your part. Next, it attracts disciplinary action from IBBI, and it may lead to liquidation if IM is delayed and no resolution plan is filed. Next, these are a few sections which talk about the penalty or any other consequence if it is there. So section 208, subsection 2, clause A, it talks about the failure to perform duties diligently. So disciplinary action can be invoked by the IBBI on the insolvency professional. Next is section 70, subsection 1. It says that deliberate omission or misconduct. Here, imprisonment up to 5 years and a fine up to 1 crore can be imposed. Next is section 65 or 66, which is related to fraudulent or wrongful conduct during the CIRP. Personal liability or criminal prosecution can be the consequence for these particular sections. Next is IBBI Inspection and Investigation Regulation 2017. If the violation here mentioned is delay or inaccurate information. Delay or inaccurate information in the information memorandum. The penalty or the consequence will be suspension or cancellation of the registration, or you can also be imposed with the fine. So monetary penalty can be there, suspension of your registration can be there, or complete cancellation could be there. So these are the consequences which are given in the code and the regulations. So let us now discuss what is the format. And before that, there is a recent circular with respect to information memorandum. Let us first check that. I'll have to again stop the screen share and I'll share the screen again. Just give me 1 minute. This circular has come in the month of March, and it is pertaining to some disclosure requirement for the information memorandum. Let's see. Anyone has any idea what is it about? I hope my screen is visible. So this is the circular number which you can see. It was issued on 17th March 2025, and it clearly talks about disclosure of information relating to carry forward of losses in information memorandum. So carry forward of losses, if the data is available, you have to disclose it. So from the returns, ITR returns, you can check that out and you have to disclose. So here it is mentioned, upon review of certain information memorandums, the board has observed that disclosure of carry forward of losses by insolvency professional needs to be more robust. Accordingly, it is hereby directed that all IPs shall include a dedicated section in the IM explicitly detailing the carry forward of losses under the Income Tax Act 1961. This section shall prominently highlight, but is not limited to, the following aspects. So 4 things they have provided, and if you have further detail, you can add on to it. First, A point, the quantum of carry forward losses available to the corporate debtor. B, a breakdown of these losses under specific heads as per the Income Tax Act 1961. C, the applicable time limits for utilizing these losses. And D point, if there are no carry forward of losses available to the corporate debtor, the information memorandum should explicitly specify the fact. So even if there is no carry forward loss, then also you have to specify that there is no amount which you can carry forward. So in both the way, you have to mention it in your information memorandum. So I hope this point is clear. So it is saying that this enhanced disclosure framework is intended to provide potential resolution applicants with a more comprehensive understanding of the corporate debtor's financial position, enabling them to develop more informed and viable resolution plans while considering the benefits of the carry forward losses. And obviously, this is a good decision, but again, we have to take care of it while checking out in the income tax returns. You can get the complete data from there. So it is now mandatory to disclose the carry forward of losses in your information memorandum. Okay. Next, we will be taking up the format, which is also given by the IBBI. Just let me open that and then I'll share the screen. So a specimen is already given for the information memorandum. How to prepare that? So whenever you have any, issues, how to disclose or anything, it will give you a complete guidance how to prepare that. I hope this is visible. There's a press release, 26 November 2018. Let me know if my screen is visible.
Yes, it is visible.
Thank you, sir. Okay, so it is saying that IBBI is inviting suggestions. It has already been concluded now. and they have already drafted, they have given the drafts of this information memorandum, evaluation metrics, request for resolution plans and resolution plans. So I'm directly going to this information memorandum part. So this is Annexure A, specimen information memorandum, table of contents. So contact details are mentioned here, disclaimer was there, and then here we have the contents. So it is divided into two parts. Part A, statutory information memorandum under IBC. Part B is business transaction information memorandum. So this is the model information memorandum. The table of contents are here. Part A, it says related sections and regulations, contents as given in regulation 36, description of assets and liabilities, financial statements, etc., etc. I think we all know this. We have already read this in regulation 36, right? So that is all listed here. So we have to disclose about assets and liabilities, creditors, dues from or to related parties, guarantees, then members or partners having 1% or more stake, then details of all material litigations and ongoing investigations, then number of workers and employees and their dues, and now a carry forward of losses will also be a part somewhere. Part B, what does Part B contains? Transaction information memorandum. First is the executive summary, key investment highlights, and indicative project timelines. So firstly, it will have the company overview, the corporate debtor profile, business evolution, project details. So all the headings are there so that you do not miss out anything. So if you go by these headings, you have to just frame the things going further. What is the shareholding pattern? What is the financial and operational claims? Everything is mentioned there. Then the industry overview, you have to give the industry, how the industry is going, what is the future of this industry, so that you can talk about the key growth drivers and the competitors analysis, obviously, and what is the outlook or the trends in the market, how you take it further. Next is the projected business plan. What is the future growth strategy? What could be the assumptions and all? EBITDA and all. Next is the annexure to the business transactions. That is IM, list of annexures to be given, and the process overview. Overall, how the process takes place in that particular corporate debtor case. So again, details are given. So see, you can see here, it is going into, or it is running into 230 pages. So there are 4 topics discussed here, 4 things which are discussed here. Information memorandum, the complete format. Then RFP was there. Then resolution plan was there. And there was one more thing. So 4 items, out of which we will discuss only one. We will not go much into detail. But I'm just here to showcase that these are the documents available on public domain. You can obviously check them out whenever you have any problem. You can see what all can be, I mean, where to present and how to present. Everything is given there. So they have taken a case also. This is the particular situation. Here they have listed out the concerned section so that you don't have to again and again go to the code or regulation to check what all is mentioned in the, what all details are mentioned there. So at one place, you have the complete picture. You have the complete knowledge for you. Everything is mentioned here, point by point, and they have highlighted in, and they have actually prepared some kind of notes for you to understand how this information memorandum goes. So this is the thing. From here, we will take up a few headings. Assets and liabilities and the financial statements, how to present it. So they have mentioned assets and liabilities with such description as on the insolvency commencement date as are generally necessary for ascertaining their values. Then description would mean what? Latest annual financial statements, how it has to be presented. They have given it in the in this format you have to present. They have showed that. Then list of creditors, financial, operational, and other employee claims, etc. You have to provide this way. Then they have given a format also like this. You can prepare the details. The next is dues to or from related party. Then again, they have given a sample format. So name of the party, trade receivable, trade payable, loans and advances, or any other thing. If you have, you can mention it here. Then guarantors detail. So personal guarantees, corporate guarantees, both are to be specified. Designation, and then how much is the facility amount, or for what the guarantee is given. Details of members or partners holding at least 1% stake. Then again, the sample format is given for you. So promoter group, non-promoter group, their address, nature of the shareholder, whether he's a promoter or non-promoter, whether the shares are fully paid up or not, and what is the percentage. So detailed description is mentioned how you have to present that kind of annexures are given for you. So for the related party, that was the annexure. Then this is for the employees. So for employees, number of employees, then classify them as regular, casual, what is their wages and salary, what is their LTA, medical payable. So everything they have given so that the resolution applicant will have a clear idea about the expenses for the employees which are to be conducted or to be made further. Then the business transactions for a corporate debtor in manufacturing sector. So they have taken a particular case wherein corporate debtor is in manufacturing sector, how to prepare the information memorandum for that particular entity. So this will be the format. These are the table of contents. Then charts are also mentioned that you have to present it by some diagrams or charts also. So this is the executive summary. ABC Limited. And then what is the product description? What are the turnkey services which it is providing, or what are the manufacturing facilities and all. So they have given you a rough idea how you can, what all headings you can take and how you can build upon it. Then what ABC offers. So obviously, then this is a kind of offer letter to the resolution applicant. So this is what we are offering. So what does ABC Limited offer? So all those operations, all its machinery and everything, you have to actually elaborate and mention that it is into this kind of business and it is having this much of capacity, production capacity, and it can produce this much I mean, these production it can have, and then it's standing in the market also. That also you can discuss. Then the transactions or the opportunities, then the key investment highlights. So it is running into pages. Everything is detailed in such a way that you can actually, sometimes it happens that we don't want to prepare information memorandum and we outsource it to someone. So maybe after checking it out, it will be easier for you to prepare it on your own. So these are the things which are mentioned here, and you can see that on your own later on also. So it has everything. So it has the location they have indicated. So charts, maps, diagrams, they are very, very important, and it has to be presented in such a way that it becomes very, very attractive for the resolution applicants. So this is the whole supply chain infrastructure and everything they have prepared. Okay, so I'm just stopping the screen share here, and let's move back to our original topic. You want to take a break at this point of time, or we can delay it after half an hour or so? You want to have a tea break now?
No, ma'am. Tea break now is must.
Tea break is must. Okay, we can get back in 10 minutes.
Okay, ma'am. Okay, thank you.
Okay, so 4:20 we will be getting back. Okay. Okay, so shall we start?
Yes, ma'am. We can start.
Yeah, just a second.
Yes, ma'am, starting.
Okay, so we have seen this recent circular and then also the contents of the information memorandum. Then let us now proceed to understand what are the common mistakes in drafting the information memorandum clauses. So we will discuss what is the mistake and how we can check that or what is the improvement area, how we can correct that mistake. So we will check both the things. So let's start. First is with respect to asset and liabilities. What is the mistake which we generally do in drafting? Only the book values are disclosed. Unregistered encumbrances or off-balance sheet liabilities are omitted. So as we understand, sometimes or mostly, these are the observations or these are the common mistakes pointed out by the disciplinary committee or the IBBI. So we should understand we have to take care of these specific things and how this can be corrected or we can avoid this kind of mistake. So we should actually conduct physical verification, review the title deeds, solicit lien confirmations from banks so that we can have proper things in hand and the proper data which we can disclose in the information memorandum. Include a schedule of encumbrances with supporting documents and update as verified. So normally we do not include this kind of schedule of encumbrances. So that is also advised that we can have that as an improvement area. Next is with respect to the financial statements. The general mistake is audited past 2 years are included, but the current year's provisional figures are missing or they are stale. For example, they are 6 months old. They are not updated or they are not up to date, just like as it was mentioned in the details in the regulation. So what is the improvement area here? Prepare the updated provisional P&L and balance sheet up to at least 1 month prior to with bank certified balance confirmation. So because we also know that now we can obtain information from the creditors and it is their duty to provide us the data. So we can have the updated details with us and from then we can prepare the provisional statements as required by the regulations. So 1 month prior or 14 months prior, whatever it is, you can prepare that accordingly. There's one more point I missed out that. So flag any material events post period end. So again, if you see any kind of material events happening, then also you have to report in the information memorandum. Next is the list of creditors. We are still to understand how to frame the clause or how to write it in the information memorandum if we do not have the complete information. So in case of lack of information, how to deal with it, we will come to it. Don't worry. That is there in the PPT. So firstly, we are quickly discussing what are the common mistakes again, and then we will be taking up the next part. In the case, because here we are specifically dealing with the mistakes. So with each heading, what is the mistake generally seen by the authorities and where we need some improvement. So in case of list of creditors, incomplete creditor list is provided. Only the financial creditors are mentioned. Small operational creditors are generally omitted. So basically we have to cross-check the COC list with the section 238 web portal. Then vendors list, tax records, utility bills, and everything we have to check and make sure that there is no creditor left out. Then clearly mark admitted, disputed, and contingent creditor liability. That again we have to do the demarcation. The next is with respect to the old related party transactions. The common mistake is only loans from directors are included. Indirect and routine transactions are ignored. How we can avoid this kind of mistake? Compile all intra-group invoices, guarantee payments, contracts with related parties, provide narrative on purpose and nature of each transaction to facilitate due diligence. Next is with respect to the guarantees. The common mistake is guarantees disclosed, but details like the expiry date, limit, beneficiary, or invocation history is missing. So besides mentioning that guarantee is there or the amount of guarantee, you have to also specify these points: the expiry date, limit, beneficiary, or the invocation history. Next is the improvement or the how to correct this kind of thing. Provide a table of guarantees. Again, you have to prepare an extra for that with proper columns and headings. Issuer, beneficiary, date, limit, invocation. So all these headings will be there. Then obviously there will be no chance to miss out anything. Supported by the copies of guarantee documents and invocation status. That also you should have ready with you. So it should be supported by the copies of guarantee documents and invocation status. Then next is employee liabilities. So number of employees and payroll details are generally missing. Dues are not fully captured. So how can we avoid this kind of mistake? You have to provide a complete list, designation, tenure, salary, statutory dues, leave balances, and provision policy. Describe the continuity impact post resolution. That also you have to specify. Then next is with respect to the litigations and disputes. Normal mistake or common mistake is only listed major suits, arbitration, show cause notices, or tax demands are generally ignored. So only listed major suits are reported, but the arbitration which is going on, show cause notices which have come at any point of time, or any tax demands are generally ignored. So that is also to be taken account for. Next, how to improve that or how to correct that? Develop a litigation database listing all the cases, including their status, claimed amounts, adverse outcomes, appeal timelines, and associated exposure. So everything has to be documented in a form of an annexure or something wherein you have the complete detail. In case of statutory dues, the common mistake is like GST, PF, ESI, property tax arrears are not quantified. So the quantification is at times missing. How to avoid that? List dues with periods, demand notices, compliance status, and timelines for appeal or payment should be recorded. The next is in case of material contracts. So only long-term contracts are noted. Utility and labor contracts are generally missed out. So how you can overcome that? Summarize each contract's nature, expiry, renewal option, critical covenants or risk, attach copies of key contracts in annexure. So again, we should have the copies of the contracts also with us. So if in any case anyone wants to check that out, we must have the copies ready and these details should be available. The next is the other material information. So what is the common mistake here? IP omits information on environmental cleanups or infrastructure commitments. So basically the ESG kind of reporting that is also to be taken care here. So include site checklist, environmental audit status, license pending, key customer concentrations, or other risk that will matter to resolution applicant. So regarding the pollution or maybe any other energy saving thing, which if it is there or if it is causing any kind of deterioration to the environment, then that also has to be reported. So that way it has to be taken care. So generally speaking, not only these, but these are a few challenges in preparing the information memorandum. See, I would take it in such a way that sometimes we are ignorant, we ourselves don't know what is to be included or how to prepare the information memorandum. So if it is something which can be studied and we can understand, with that is in our control only. So we have already discussed that part. So wherefrom you can understand what is information memorandum, what is to be included, and what is the regulation, wherein the details are given. So format and all, everything we have discussed. So from the point of view which is in our control or what we can sort out on our own is already discussed. The next challenge is not in our control, probably. So sometimes we do not have access to the corporate debtors things, or we don't have the access to the data of CD or something like that. So other situations or other challenges could be like we have the data but it is outdated or it is incomplete, and there is non-cooperation by the CD or other people, that how to complete those records. Sometimes the hard disk or the data wherever it is stored, that is not shared with us. The IDs and passwords are not shared with us. So how can we get the complete information for preparing the information memorandum? So some things are there which are beyond control. Then there is determining material information. Sometimes we do not understand from the point of view of that business what is material, what could be material information. Then there is complexity of the corporate structure. Sometimes it is so much complicated. A lot of entities are involved and a lot of transactions are going within the group itself, that it becomes very difficult to understand the whole scenario because the time limit is very short for all of us. So within the time frame we have to act. If we had the unlimited time, we could have cracked each and every thing. But the solution is not available in a very short span of time, and there we are stuck. So time constraint is obviously a problem, and with these challenges, how to go further, that is the next topic for the session. So the challenges here which we will be discussing are not obviously in our control. How can we mitigate these kind of challenges? So first challenge could be non-cooperation from the management or the directors. How to cope up with it? Immediately file an application under section 19(2) of IBC before NCLT for the direction. That is for the non-cooperation of the management. So if you are trying hard, reaching out to them, but still they are not cooperating with you, to be on a safer side, because you have to say that it's not my fault. The process is delayed. It's not because of me. So in order to ensure that, you have to show some document that you tried at your level best. So whatever mails you have made, or whatever if you have filed any application under section 19(2), that would be a very good evidence to show that you had tried your level best. Otherwise, obviously, it will be a breach on your part if the things are not prepared on time. Next is use statutory filings, tax records, that is GST or ITR or ROC data as independent sources. So don't just rely on the management or the directors to provide you the information. Figure out third party or somewhere else you can get the source or some other source from where you can get the data. So figure out somewhere or the other you will find the source for your details. Next is consider the forensic support to reconstruct the books from third-party data like banks, vendors, etc. So that could be the possible solution in case there is a non-cooperation from management or the directors. Next is in case of incomplete or unreliable financial records. So though you have the records, you have some sort of financial records, but they are either incomplete or they are not reliable. So what is to be done in that case? So firstly, you need to appoint a forensic accountant to reconcile the bank statements and the statutory returns. Use the audited reports of subsidiary and consolidated accounts wherever it is applicable. Engage statutory auditors to assist in reconstruction. So as we understand that the time limit is very short for all of us to perform within that specific timeline. So don't take everything on your own. You are free to appoint as many professionals as you want to make your work of to make the things go faster. So in that case, to increase your efficiency, don't wait to appoint the forensic auditor or any other person or any other professional at the last point of time. You can take their help from the very beginning. If you think that things are very complicated, it is not coming into your control, then you have the authority to appoint the people. You can bring it to the notice of the COC that since there is this kind of complication and we need to have some professional appointed, because again, their fees, their cost obviously will be taken care by the COC only, and everything has to be taken on record. So that is the ultimate thing which we should understand. We should not keep the things to ourselves only. We should take help of the other professionals from the very beginning itself. Next, disputed claims and valuation certainty. Establish a cutoff date and disclose disputed claims separately in the information memorandum. Highlight the basis for provisional admission in the notes. For valuation, engage experienced valuers who can factor uncertainties. Now here, one more point I would like to specify. For the valuation purpose, for each category of the assets, you can have different valuers. So it's not that for the, if you have appointed someone for the for valuation of land and building, the same person will be taking care of the plant and machinery. You can have different valuers, and obviously for different class of assets, you should have different valuers so that simultaneously your work can conclude in time. Next is timelines and procedural delays. Create a CIRP calendar at the outset and communicate it to the COC and stakeholders. You have to regularly update that this is the timeline within which we want to work and this is the status as on date. And delay is because of this and that reason. That also you must communicate. Parallel track activities, claim verification, data room setup, and valuer appointment. So parallelly, you have to track all these activities also, whether they are falling into place in time or not. Next is prioritize critical data for initial information memorandum, and then update it with any annexures if required or if it is necessary. Next is confidentiality risk. In order to mitigate this, what can be done? Strict enforcement of Regulation 36(4) is required. Obtain board resolution and indemnity from the applicants with respect to the confidentiality. Then use secure VDRs with role-based access control and activity logs. Obviously, this is very, very important in the age of digital information. It can be misused at any point of time. So you have to have the proper access control and the activity logs as well. Then include legal review of all the data sharing protocols. Next is legal regulatory risk and the liability. Then the ways to overcome this kind of challenges: maintain a robust documentation like working papers, the correspondence logs, source data, etc. Don't just keep things verbally. You have to have the working papers in hand to showcase that actually this was done. So all your mails, the trail of that can be preserved, or whenever you are sending notices and all, everything has to be documented. Next is engage legal advisors to vet the disclosures and confidentiality undertaking. So again, don't keep the things to yourself. You can always appoint some professional and do the work for you. The next is share regular updates with IBBI if delays or dispute arises. So this is something which we all should understand, that communication with the authorities is very, very important. Otherwise, they will, blame you only for all the this delay and breach. Okay, now next we have a few more case studies to discuss the common challenges which we are facing and how we can overcome that. So I'll just stop the presentation here and I will share it from the other slide.
Ma'am, I have a question.
Sure, ma'am.
Ma'am, actually, when we talk about litigations, how do you get to know where the cases are listed? If the management is not telling you, how will you get to know?
Okay, so if we can check out with from the balance sheet also what all transactions have taken place, and some amounts are pending since long.
No,
with
that
some
is regarding
departments and
only
all.
if they are getting that is reflected in the financials. If that
Of
is not
course,
the case, then
financials. Yes, yes, from financials only. And because from financial point of view, I can tell you from the balance sheet, you can figure out a few things. And then it is open for you to inquire from the employees or the other members also if there is some, if you think there is some suspicious activity going on or any litigation is going on. So from the legal team also, some companies also have their legal team. So you can always connect with them and get to know what all cases are pending. You will find some or the other legal fees in their P&L account that is there. So you can always inquire for what reason this legal fees is there, or for what reason, the case is going on. You will find something or the other by interacting with the staff or with the key officials of the company, and also from the financials of the this corporate debtor.
okay. Thank you, madam. Thank you.
Okay, let me just share the screen. Otherwise, also from the nature of the business, we can identify what are the regulatory authorities for this particular uh, business, or for this particular entity. For example, in case of manufacturing company, suppose it is a food manufacturing company. So in that case, what are the regulatory authorities could be there? So we can directly send them. We can directly send them an email and ask them whether there is any due from the corporate debtor, anything which is due from the side of the corporate debtor, anything is payable from them, or any litigation is going on. So from the regulatory authorities, obviously, from the nature of the business, we can identify if any due is pending, or in case of the outstanding debtors or creditors, that also you can make out from the financial records only. So that way, I think it will help you out. Now, I think my screen is visible.
Yeah, yes, ma'am.
These are some case studies on the information memorandum. Should I increase the font size just a sec? I think this will be better. Okay. 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 So the first case is with respect to a real sector entity. Here, the buyer's record are missing. So how to deal with this kind of situation? So we have just taken a dummy example for that. The company name is Metro Sky Infratech Limited, and CIRP has already commenced on 5th Feb 2025. The scenario is like the corporate debtor has not handed over the list of home buyers for two major projects. So project by project, they have to hand over the details, but they have not handed over the details of two major projects, wherein 120 crore in advances the advance amount was received for rupees 120 crores. RERA dashboard access was not provided to you. So how can you directly check the records? So that is the situation which we are seeing here. Next is suspended director claims that the data is in the laptop and that laptop has crashed. So we cannot provide you the data. So he's simply saying, the directors are simply saying that we cannot give any kind of data to you. Help it on your own, find it on your own, how to get it. We will not help you out in any case. So the thing is that we don't have the information about the two major projects. The list of home buyers is missing. So if we do not have the complete details of the creditors, how can we, figure out the proper payment, or how we can, go with the waterfall plan, how that will be allocated, that amount will be allocated. So what are the red flags seen in this particular case? Firstly, the escrow shortfall is not traceable. So since the amount, we cannot identify how and where to trace, and to whom it, who has not, whose detail is missing, or whose amount is not there. Next is home buyer claims under Form CA is not reconcilable. Again, this is also a kind of red flag. If the homebuyer claims which are given under Form CA, they cannot be reconciled from any of the source. So how can you justify or how can you verify that their claims is correct? Next is deliberate suppression is suspected. Obviously, since the suspended director is saying that the laptop has crashed and we cannot provide you the data, it is a kind of deliberate suppression of data which he's trying to do. So what will be the suggested action plan for you in this case? If you go by the legal provision, if you want to take a legal step here, firstly, you should file the NCLT application under section 19(2) for non-cooperation. So this is something which is very, very important in this regard, because we have clearly seen that we are short of data. We do not have enough data, and even after approaching the directors, they are not providing us the data. So that is something we should work out for. Then next we can go for the third-party resource. Third-party source we should go for. So obtain data from RERA portal and escrow bank. So if they are not providing you the login ID password, then you can directly approach the authorities and then you can say that I'm the resolution professional for this particular entity and it is undergoing the proceedings and we want to have the details. So obviously the authorities will help you out. You have that kind of power with you. You can use your power and get the things from the other authorities. Then this is also mentioned in 18(1)(f). You have the access to the records of the corporate debtor. The next is disclosure. How to disclose this in the information memorandum? So add incomplete buyer data clause in the information memorandum. So besides the points which are there in the information memorandum, you can have one more additional clause there saying incomplete buyer data, and then you can present the details whatever you have, and then also you can update the COC regarding that. So you had updated the COC, that also you can mention. Whatever thing you want to be, whatever thing you want to say, you have to specify that in writing. That is utmost required, and this is given in regulations. These regulations are the respective provisions which are given in these regulations. So this will be a kind of sample disclosure. So may I please ask you to mute yourself? Okay. Sample information disclosure for this particular case will be data relating to suppose 184 home buyers of project Metro Sky Towers is not available with the RP due to non-cooperation from the suspended management. Claims from home buyers have been admitted based on Form CA and bank entries. Escrow reconciliation with the ICICI Bank is underway. So you have completely disclosed whatever data you had, whatever restrictions you had, and so that blame will not be on you that these things are not conveyed. So you have already conveyed it from your point of view. You have also said that the management had not cooperated with you, and still we are on our way to do the reconciliation. We are following up with the bank, but at this point of time, we don't have much details for that. So we can simply disclose it in the information memorandum on a safer side. So again, if you are disclosing this kind of thing in the information memorandum, again, there should be a few points which should come to your mind. First is, can COC proceed with a plan in absence of the full buyer detail? Again, that is a different point to be discussed. Then how to value incomplete receivables? Should forensic audit be initiated? So all these points should also be simultaneously thought before you make this kind of disclosure, and you should be ready with all the solutions before you put this kind of disclosure. Coming to the next case study, which is for the pharma sector. Here, the licenses and the audit reports were hidden. So again, taking example, Zaventa Life Sciences Private Limited. Here the CIRP started on 10th January 2025. These are just dummy cases. We are just discussing a few cases. It's not real case. So what is the scenario? US FDA, this is a kind of license, United States Food and Drug Administration license, or which is given to the pharma sector industries. Here, the warning letter was received in December 24, but not shared with the RP. Though the management has this warning letter from the authorities, but they have not shared it with RP. Next, CDSCO, that is Central Drug Standard Control Organization license for one of the key plant expired in November 2024. So for one, we have received a letter, warning letter, that it will soon be, discontinued. This kind of registration or the license will be discontinued. For the second one, the license is already expired. The third one is management claims license renewal is in process. So we are told that license renewal is in process. What could be the red flags in this particular circumstance? First is the export dependency is more than 65% here, though we do not have the complete financials, but it is, suppose this case is given to us that here the entity has export dependency, which is more than 65%. Stock of affected product worth rupees 8 crores, and there's no internal compliance officer available. So the stakes are huge, and there is no responsible person to take care of also. So what could be the suggested action plan? First is with respect to the enforcement. Again, you have to apply to NCLT under section 70. You can mention it as fraudulent withholding, because as per the section, if some fraudulent activity is going on, or if this kind of thing is happening, then you can always report it out according to the sections which are given in the IBC. The next is alternative source. Retrieve the audit information from US FDA, CDSCO websites prior regulatory filings. So it's just that we don't have the current year or the past year information, but before that, the earlier year data you might be having. You can obtain the details from the relevant authorities from their websites, their prior regulatory filings. Like in income tax, if we talk about, we can always access to the previous records. So that way we can have the sources from where we can obtain the information, whether the license is actually expired or not, when it was due, whether the process for new application has been filed, the application for new application for renewal has been filed, or something like that. You can always check on the websites, or you can always connect with the authorities to obtain the information. Or if there is any kind of penalty which is going on these on this particular entity, then the valuation caution. Ask the valuer to apply regulatory impairment discount. So this is something which we should advise from our intellect, that valuer, while doing the valuation, he has to give a proper regulatory impairment discount for this particular case, because it might happen that they will lose the licenses going further. So how can you disclose it in your information memorandum? As on date, CDSCO license for particular facility stands expired and pending renewal. A US FDA warning letter dated this was identified through external sources but not handed over. No compliance documentation available with the RP, or whatever you want to specify. Just specify whatever information you have obtained from wherever you have obtained. And if you suspect any kind of implication on the decision of the resolution applicant based on this, then in that scenario you must disclose it from your side. Then again, there could be some other questions which may come to your mind regarding the regulatory impairment of the asset value and all. So we are not discussing that as of now. For NBFC, one case study is there, and then one we have for logistics. So we can discuss this logistics one first. The company name is Move Express Logistics Limited. CIRP started on 12th April 2025. The scenario is like 120 trucks shown in fixed asset schedule. On verification, only 85 are operational, 20 repossessed by NBFC, and 15 are scrapped. RC and permits are not handed over. What could be the red flags in these situations? Valuation is based on assumed fitness. Toll default notices are pending. Warehouse lease also lapsed. So again, you have to search, you have to think from the perspective of the management, what could be the affected areas, and then you can check into those particular things and you can obtain various information, though it is not communicated directly to you. But again, obviously you have to apply your mind based on the industry, and then you have to figure out what else could be the non-compliance. So again, what could be the suggested plan for this? You can go for site verification, conduct asset survey through valuer and transport consultant. Then you can document the recovery, obtain RC copies from RTO and loan agreements from NBFC. Disclaimers: update IM with truck-wise status and document gaps. So truck-wise detail you'll have to prepare, and you have to disclose that. So sample disclosure would be like, fleet schedule is partially verified as per the site inspection and lender communication. Only 85 trucks are operational, 20 have been repossessed, 15 are declared unserviceable, title and fitness documents are not handed over. So this kind of thing you can always mention, and this is something what you have to check for each of these headings. So like for assets and liabilities, you should have a summary table, an excerpt from the books, and the valuer's notes. That is something which you have to highlight in your information memorandum. Then for the financial statements, audited and unaudited financials, plus the audit qualification if there is any, then also you have to mention it in the information memorandum. Then in case of list of creditors, category-wise summary for financial creditors or operational creditors or employees, etc., with their claims and admitted amounts, that everything has to be disclosed. In case of workmen and employees dues, claim form, PF, ESI, bonus, payroll, default analysis, everything is to be mentioned. Then in case of guarantee given or received, corporate or personal guarantees, their validity, invocation, etc. has to be detailed. Then in litigation and proceedings, summary of legal disputes like criminal, tax, commercial, RERA, etc. So all kinds of litigations, all kinds of proceedings, you have to guess, you have to identify, you have to check, and then you have to report out. The next is statutory dues, GST, income tax, property tax, PF, TDS, environmental compliance, etc. So being a professional, we all understand on a particular industry what all rules and regulations are applicable, or what all laws are applicable. So accordingly, you can always reach out whether there is any pendency, or whether there is any pending suit, or there is any litigation going on, or any penalty action is imposed, or any dues are there. You can always figure out based on your knowledge base on a particular industry. So that way you can always proceed. Next is other material information, RERA status, NOC, major customer exits, license expiry, unresolved statutory notices, etc. Then this is simple. This is something which we should not discuss. Okay, next, I think I'll have to switch the slides again. Just give me a second. So we could take just a few cases, maybe that you have not yet encountered with these particular industries like pharma industry or any logistics industry, maybe. But whenever you come across with such a situation, you can figure out how to proceed. So that way it can be taken care. So these are the checkpoints. Let us quickly recollect what we should do further. I mean, these are in addition, whatever we have studied for the information memorandum. You should always take care that it is shared only with the eligible resolution applicants, only after you receive the signed non-disclosure agreement. So you should always check whether you have received the non-disclosure agreement, and then only you have to share it with them. Next is whether the IM is prepared within 95 days from this insolvency commencement date or not. So these are a few checkpoints beyond the contents also. These points are also very crucial to be taken care. Then next is updated information memorandum issued after COC change or new disclosures. So again, you have to update the information memorandum if there is any change. Then valuation disclaimers, whether you have included or not. So it's not just the valuation you have to include, but if there is any disclaimer, obviously, and also the audit qualification, if there are any, you have to include. The next, data limitation disclosed transparently, whether there was any limitation in the data. Just now we have seen that some data was not available. So this has to be separately disclosed. So don't keep things to yourself, but you can always disclose it in the information memorandum. Next is, can IM be accessed on the public domain? What do you think? Can information memorandum be accessed on public domain? Can we check out the information memorandum of any of the corporate debtors whose application is pending? Although the resolution has already happened, and can we still check the information memorandum of those? Is there any database where these are stored, information memorandums? Anyone? Can we access the information memorandum on public domain? I think the answer
We
is
cannot
yes.
put in public domain because the IM is a confidential document.
Perfectly, sir. That is the first line which I have mentioned in my next slide. IM is not a public document. It is a confidential document. So it is only between the persons with whom it is shared. It is not available publicly. It contains the sensitive business data, trade secrets, customer supplier list, litigation risk, and everything. So it is not there in the public domain. It may also influence the valuation, bidding strategy, or plan the manipulation, or it may have some or the other consequences on the resolution plan itself. So that is why it is not there in the public domain. Disclosure may violate the NDAs, competition laws, or privilege. It may provide privilege to some other parties. So that is why we can say that it is not open for all. It is a restricted document. So if we talk about the legal provisions in the code, section 29, subsection 2 of IBC, it clearly says that RP shall provide the information memorandum only to those persons who have submitted expression of interest and have met the eligibility criteria under section 25(2)(h) and signed a confidentiality undertaking. So besides them, this is not shared with anyone else. Obviously, COC will be given this document, but besides them, outsiders, we are talking about the outsiders. So no one else is given this kind of document. Then IBBI regulation 36A, sub-regulation 10, it also says that IM shall be shared only with the prospective resolution applicant who comply with section 29A and sign a confidentiality undertaking. So who all can legally access the information memorandum? So COC members they will automatically access through RP. Prospective resolution applicants, they will have an access for this information memorandum, but only after submitting their EOI, showing that they are eligible and submitting the non-disclosure agreement, signing the non-disclosure agreement. The next is whether IBBI or NCLT, can they access the information memorandum? Yes, for inspection or in any litigation purpose, they can access the information memorandum. Then what about the liquidator? That if CIRP failure if CIRP fails, then in case of liquidation, what about the liquidator? So liquidator may request for future sale process reference. He can have an access, obviously, for this information memorandum. So it may happen that the person has changed. The person who was the resolution professional is not the liquidator now. So again, he can have the data with him. The information memorandum he can also have. Next, records. What shall be the action plan for IPs when the records are unavailable, or in case of any non-cooperation? So this slide from here onwards, it is an extension to what we have already discussed. So we have discussed some legal things which can be which we can take which we can use for our own, like we can send a notice to the 19.2. We can apply this section 19.2 for non-cooperation, and we can ask the adjudicating authority that non-cooperation is happening with the corporate debtor is not providing enough cooperation. He is not cooperating at all. So 19.2 is the safeguard for us. Similarly, there are other provisions wherein we can take shelter of. And again, there are some more points which can be taken help of, which can be taken as a shelter, or which can be used as an action plan in case the records are unavailable or in case of any non-cooperation. So if document, if you have already taken reasonable attempts to get the documents, but still they are not being made available to you, what you can do is issue formal notice to corporate debtor, even to the suspended directors, requesting records within 7 days. This is clearly mentioned in section 19.2. This we have already discussed. And why it matters? Because mandatory for a building case of non-cooperation. If you really want to file a case for non-cooperation, you have to show that you have issued a formal notice to the corporate debtor asking for the records. Then file written communication log. So emails, courier proofs, etc. You should have a proper record. So RP should maintain a record book which will help him in future compliances and audit, and it will create a kind of evidence trail that he has actually made several attempts to get the documents. Next is to conduct basic forensic scan of the available data, that is ERP or the Gmail account or the bank details which you have, the bank account details which you have. So forensic CA can be appointed, or IT auditor can be appointed to make the data available for you. Even if the data is not provided to you, you can create or recreate the data by using the professional help. So even partial access helps to track the fund flow and the gaps. So even if full information is not there, at least you have something to start the work. Next is you can take the legal recourse via NCLT. Obviously, you can file an application under section 19.2. Here you have to show that you had already sent notices to the directors earlier to provide the information. So next is invoke section 70 for misconduct or fraudulent concealment. Here the provision is given for the penalty and imprisonment in the IBC. We have seen that also earlier. What could be the expected relief? It deters the evasion and alerts the creditors that this can also happen on us. So we have to be, we should provide the details to the resolution professional. So we have to, create a kind of fear in the minds of the other stakeholders also, that it's not that just the resolution professional will keep on asking for the details. It should be their duty also to provide us the details. We have to create such an environment now. So request NCLT permission for forensic audit of key areas. So section 25 read with CIRP regulation 36, it provides you this kind of power that you can request NCLT to seek permission for forensic audit of some key areas. It enables external tracing of the data, funds, assets, etc. So obviously, if there is non-cooperation from the corporate debtor, then obviously you can do with any of your means, you have all the authority to find out or to trace out the information. So you can take help of the other professionals also in this regard. Next is you can also discover the data or discover the various things from the third parties also. You should not only rely on single corporate data or the one person only. You can, this we have already discussed in earlier slides also. And here again, it is saying whom all to approach to. So we can approach to bankers, we can approach to the GST authorities, we can check the GST portal, ROC or MCA portal, as we know, income tax portal, whatever, online methods from where all you can approach the authorities. You can go to their offices also directly, or online also help can be provided to you. So you can cross verify the details which you already have, or if you don't have the details, you can seek the information from them. You have all the authority to do so. Next. So these are some recommended information memorandum disclosures. So even if documents are unavailable, you must include the risk transparently in the information memorandum. Don't ever assume that whatever information you have is sufficient. It might happen that there are something still missing. So even if you have taken the help of third parties, or you have taken the shelter of legal reports or anything, still there might be a risk of some information which are missing. So you can put this as a disclosure in the information memorandum. This is specifically with respect to the situation if the data is missing. No data was received regarding the company's CRM system or whatever system, loyalty program liabilities, or warehouse licensing compliance. I mean, wherever you think that the information is missing, you mention that. Okay. Despite written request and follow-up reminders, the suspended management has not handed over the excess credentials. This poses a material uncertainty to the valuation and may impact the feasibility of any resolution plan. So this is the sample language which we can use, or maybe you can reframe on as per your convenience. Whatever things you want to add, you may do that. But it is very, very important to disclose such a thing in your information memorandum. So this helps you to avoid section 208 and section 70 proceedings, which are obviously penalty provisions. Next, it helps you to comply with regulation 36(2) in substance, because it clearly says you have to point out or mention with respect to each and every heading. And if we don't have the detail, how can we? So we are putting that disclaimer from our side. Next is transfer informed risk to the COC and RAs. So you have already conveyed the information, whatever you had. Now it is up to the COC or RAs to take the decision. Next is suggested precautionary clauses in IM, that is information memorandum. These are also some of the suggested these clauses which you can have, or this is the kind of language which you can use. Disclaimer on missing records. The RP has relied on third-party and publicly available resources where primary records were unavailable due to non-cooperation. So this could be one of the lines which you can add in between, or you can start with whatever, and then you can, complete whatever the details were missing or whatever thing. So this could be also added in case of missing records. Then in case of material uncertainty note, valuation of fixed assets does not account. Hello, yeah. Anyone wants to ask anything?
Hello.
So please mute yourself and then you can.
हाँ थे चले जाओ और मेरे को बात करा दो, थे भी समझ लो, या अपनी कोर इन्वेस्टमेंट कंपनी है अभी।
हाँ जी. Next is material uncertainty note. For valuation of fixed assets does not account for any title irregularity due to lack of land records. You can specifically mention that the land records were not available, or maybe something like that. But you have to be clearly, disclosing these things in information record. If you are not in a habit of doing so, now you have to start this kind of thing. Next is forensic risk alert. Unexplained fund flows amounting to, suppose 4.2 crores detected. Audit is underway. Resolution plan should incorporate the risk, and the risk will buffer accordingly. So that is something you have already highlighted in the information memorandum. You cannot wait for the complete audit process to, you cannot wait for the audit to complete, because you have a very strict timeline to follow. You have to present this information memorandum within the specific time. So whatever information you have, even if you have incomplete information, even if you have assigned the duties to other professionals to work upon, you can still mention it. You can say that reports will be out soon or something. There is risk involved, and whatever you want, you can speak that out in your information memorandum. So these are a few do's and don'ts, or the best practice we can say. Use legal notice as a documentation trail. These are the do's. And then mention data not available explicitly. Then escalate to COC early if fraud is suspected. So we should not hesitate in mentioning that the data is not available, because otherwise we will be blamed that we did not search it out on our own, or we will be made negligent for all these things. Then don'ts. Don't delay application under section 19. Don't ever think that because the management will keep saying that we will provide you the data in some time, it will take time and all. But since we have to act within time frame, you should never delay this kind of application under section 19. You should have proper records that you tried to obtain information. Again and again, it is mentioned in various of my slides that you have to have this kind of evidence that you tried to connect with the management, you tried to connect with the creditors and all, but they are not cooperating. So this is something which you can always take, you have to take a record of. The next is don't rely on oral confirmations from ex-management. Obviously, the ex-management will never be bothered. So it's better to, send emails to them so that you have written confirmations or written evidence to show that, yes, we have connected with them as well. And even then we are not getting the information. Don't include partial data as fact without any caveat. So even if you are putting partial data or incomplete data, then put a proper condition or a proper disclaimer that it could lead to such kind of risk, or it may have such kind of risk or whatever. There are some more points which you have to take care, and these are the last two slides, and we will come to an end of this session. So area of disclosure, suppose in case of assets and liabilities, description you have to mention. So description we already studied earlier what you mean by description. Then what are the documents required? Because how will you come across what is the description, what is the detail of the asset, what is the amount, depreciation, etc. So for that you need these documentation. So as soon as you have an assignment, you should check whether balance sheet is there, fixed asset register is there, title deeds are available, charge register is there or not, inventory report is there or not. If it is not available with the corporate debtor, or they are not providing you the details, then obviously you can search it on the MCA portal, or you can check the banks wherein some information might be there. So without wasting time, you should move to the third party to collect the information. Next is consequences of non-disclosure. If you do not disclose what is required for this particular assets and liabilities category, then it will obviously be misleading net worth and improper valuation, obviously. So it will not provide a fair picture to the resolution applicant. So next is what is the legal provision of penalty with respect to this? So if you are not presenting in a way in which it is demanded or in which it is required, then obviously these sections will make you responsible for the misconduct or breach on your part, and an IBBI can take a disciplinary action on you. So we have to be very cautious for this. The next heading is secured or unsecured creditors. So in this category, again, the names, amounts, security details, guarantees, etc. we have to mention. Then loan agreements. So for mentioning all these details, what all records do you want to have? So we should have the loan agreements, charge registration, board resolutions, etc. Obviously, the financial statements will provide you the data. And again, if the data is not available with the corporate data, and if they are obviously not providing you the data, again, you can check it out on the MCA portal, because charges have to be registered. We all know that. So you can get the details from there. Then consequences of non-disclosure, it will affect the plan feasibility, debt resolution strategy. We all know this. So it's better to just discuss what all documents we need to have. For understanding the related party transaction, past and ongoing, both the transactions have to be reported. So ledger extracts, board minutes, then disclosure from auditors is required. We all understand that for related party, disclosures are required in income tax, as well as from the point of view of companies reporting for MCA purpose also. We need to have some separate disclosures. So we will have it on, we can obtain the information from different portals also. So that way, it's better to, search it out for ourselves rather than asking the corporate debtor. Even if they are not providing the data, we have enough sources to obtain the data. Then next is financial statements for preceding 2 years and provisional. We know both the things have to be presented. So what all documents we require for that? So audited financials are required, obviously. Then trial balance, bank statement. If you want to present the details for the provisionals, then obviously from the bank details, bank statements, you will be able to draft the financials. So again, you can take help of the professionals, and you can recreate or you can create the data. So even if the again, the corporate data, if it is not responding, you can obviously track your own sources, how you can get the data. So if there is any gap in the financial planning, if there is any inability to access the viability, obviously the things will be blamed on us if proper reporting is not done. So again, it is very important to have all the data. Then next is regarding disputes and litigation. We need to have the case summaries, court orders, legal opinions sought. So again, this is already discussed. Then next is guarantees given. So wherever guarantee is given, you will have the guarantee deeds, sanction letters, etc. You can have it with the corporate debtor itself, or maybe with the third party. You can always access to those informations. Then the employee liabilities, payroll registers, PF, ESIC challans, HR reports, etc. Or if returns are filed for that, you can trace the data from there also. Then next, statutory dues. How can you figure out the statutory dues? What to report, how to report, everything. You need to have the returns filed, assessment orders, if any. So from there on, you can collect the information, and then you can present it in the way it is required. So if something is, not disclosed, or it is hidden, or maybe it was not intentional but you did not report, then obviously it may amount to the resolution plan rejection later on, and penalty can be imposed on the insolvency professional for his misreporting under the IBBI code of conduct. So that's it from my side. We are open for any questions if you have.
Ma'am, please share the PPT. It will be very useful.
100% now.
Yeah, thank you. Thank you so much.
So Shyam sir is asking, and I can see one question in the chat box. Can we approach the auditors for the audit file and papers? Of course we can. So obviously professionals help each other. There is no problem in approaching any of the. And obviously discussion is very important. If you come across any kind of situation where you are stuck somewhere, it is always better to discuss it amongst yourself. Maybe with a peer discussion, you will come up with the ideas how to get it resolved, rather than waiting for the solution from anyone else. I mean, it's always that the professionals can discuss within themselves and they can come up with the better ideas.
Ma'am, if we file an application under section 19
Hmm.
and still the directors or the board will not provide the documents.
Obviously,
what-
they will not, sir. It mostly it happens that they do not. Intentionally, they don't want to. So,
Then what
sir,
option we have?
first, on a safer side, we have reported it out. So it's not our fault at all. We have tried our level best. What is to be done is now NCLT to decide.
Okay, ma'am.
Yeah. But the whole idea is that don't keep the things to yourself.
But ma'am, NCLT ordered the directors to provide the documents. Still, they are not
Implementation is not. Yeah, they cannot implement.
So
They cannot
if we
force
go,
actually. Again, you have to apply to them only. You have to ask the adjudicating authority again that even after your order, this is not been corrected.
contempt of court, something like that.
Yeah.
But मैम ऐसा पर्सनल लेवल पे हो जाएगा कि आप हमें कंटेम्प्ट फाइल कर रहे हो तो पर्सनल लेवल पे दुश्मनी हो जाती है ऐसे को.
अब सर ये तो रिस्की है ही. या तो आप करो ही मत, तो कंप्लेन करते इसीलिए तो नहीं है कि हमें केस चाहिए हमारा. कंप्लेन करेंगे तो मिलेगा नहीं. नॉर्मली हम लोग इसीलिए तो कंप्लेन नहीं करते.
फाइन, ठीक है, ठीक है.
Any questions from anybody else? Okay, then can we wind up the session?
Okay, ma'am. Okay. Thank you, ma'am.
Okay.
Thank you very much, ma'am.
Thank you. My pleasure. My pleasure.
Okay. Thank you. Thank you very much.
Thank you.
Thank you very much. Excellent session.